time you buy something or you sell something, whether a gadget or bread, you are entering what the law calls sales of good. But what exactly does it mean? Hi everyone, I am really a law student. For those who do not know me, I love simplifying legal concepts into simpler terms for easier understanding. And today we will be discussing about the introduction to sales of goods. The law governing the sales of good in Nigeria is the Sales of Good Act 1893. Yes, I repeat, the law governing the sales of good in Nigeria is the Sales of Good Act 1893. So what then is the definition of sales of good? So pursuant to section 1 sub 1 of the Sales of Good Act 1893, it's defined sales of good, yes, it's very sales of good as a contract whereby the seller transfer or agree to transfer property and goods to the seller or to the buyer. I repeat, it's a contract whereby the seller transfers or agrees to transfer the property and good to the buyer for a monetary consideration called the price. I'll go again. Pursuant to Section 1 sub 1 of the Sales of Goods Act, it defined sales of goods as a contract whereby the seller transfers or agrees to transfer the property to the buyer for a monetary compensation called the price. So from this definition, we can see two keywords there. Like it's a situation whereby the seller agreed to transfer goods, the seller agreed to transfer goods, and also that the seller transfer goods. There are two major, they are slightly different. They are not exactly the same thing. To transfer good and agrees to transfer good to the buyer. Going further, section 1 sub 4 of the Sales of Goods Act, it differentiates between an agreement to sell and a contract of sale. You know, I told you that from the definition, there are two different keywords there, which is to transfer and then agrees to transfer goods to the buyer. So now in section 1 sub 4 of Sales of Goods that is explaining it better for us to know the difference between that two, and that is an agreement to sell and a contract of sale. So for contract of sale, that is where it is a situation whereby the contract, like the agreement, takes place at the particular moment where the contract is being negotiated. Like the contract takes place exactly the moment where they want to, like where they are trying to negotiate, where they are contracting. For instance, now maybe Mr. A wants to buy something from me, and then I sell it to Mr. Mr. B wants to buy something from me, Mr. A. Then I sell that thing immediately to Mr. B. Then that is contract of sale because the sale is taking place at the instant where the contract is being negotiated or is being held. Why an agreement to sell? That one is quite different from a contract to sell. While contract to sell take place at the initial place where the contract is being held, an agreement to sell would usually take place at a further time, at a later date, at a future date, or after some fulfillment of certain condition before the contract will come into non-existence. For instance, whether the seller asks the buyer to fulfill some certain things before the goods will be handed over to the buyer, that is an agreement to sell. It is not actually a contract to sell because it is not taking place at the point where they agree to buy the good or to sell the good. It's going to take place at a future date or after the fulfillment of some certain condition. I hope a contract to sell and then agreement to sell is well explained. Contract to sell will take place at the point where the contract is being negotiated, while an agreement to sell will take place at a future date after the fulfillment of some certain condition by the buyer or from both parties, either of the two. Moving on to what goods are. Pursuant to Section 62 sub 1 of the Sales of Goods Act 1893, it defines what goods are. So goods include chattel personnel, implements, industrial growing crops, things forming part or are attached to the land, excluding things in action and money, and they are required to be severed before the contract of sales. I'll repeat it. Goods are chattel personnel, implements, industrial growing crop, things forming part or attached to the land, and excluding things in action and money, provided that they are to be severed before the contract of sale. As you can see from this definition, we have various keywords which include we have chattel personnel, that is one good. We have implement, another good. We have industrial growing crops, another good. We also have things forming part or attached to the land, that is another good. Then we have excluding, those excluding are what are not good. Yes, they are not classified as good, and they are things in action and money. So we have major four goods there. We have chattel personnel, implements, industrial growing crops, and then things forming part or attached to the land. Then we have the exception, that is things in action and money. Now for chattel personnel. Chattel personnel are movable and tangible goods such as cars, clothes, shoes, furniture. I'll explain them better. These are goods that you can own yourself. These are goods that you possess, that you can sell, you can transfer, or in fact you can buy. They are tangible things, they are things you can move. So the law consider them as goods. They are goods because they are tangible. They are what you can sell out to people. Like you have possession of them and they are tangible enough for you to sell them out to another person. An example include cars. Cars, you can move cars, you can hold cars, you can sell it out to other person, and you can also buy too. So they are chattel personnel because they are movable and tangible goods. So they are part of goods. Another one is implements. Implements are natural resources that require the annual labor of man. They require the annual labor of man. For example, we have maize, yam, cassava. You see that they will not grow without the labor of man. Yes, without human effort without human effort, without human labor, they will not grow as good for us to sell because they are natural resources and they are required to be grown like they are required to be grown by man before we can sell them as good. So they are also another example of good because the law do not consider them as part of land, do not consider them as land. They see them as what we human can grow, and then after it is already ripe, then we can sell it out as good. So implements and chattel person. So you see the difference between chattel personnel and implement. Chattel personnel are movable, tangible things like cars, like everything you own, every tangible things you own, they are goods. They are something so far as you can sell, you can buy them, you can move them, they are tangible, they are goods, they are called chattel personnel or no. Why implements? Implements are natural resources that they require human effort before they can be referred to as good. They have to be like you have to grow them to do every necessary things before they will be finally considered as good, and then you can sell them. I already said example, we have cassava, we have yam, and so on. We also have industrial growing crops. Industrial growing crops, these are this is also another example of this is also another example of goods. It is somehow like implement, but maybe a slight difference here. Maybe a slight difference, yes, because implement also requires human effort before it will be termed as good. But the distinction there is that this one will not grow annually. For implement has to grow annually. For example, now you know yam, it grows annually. You will see that at some particular period, yam will be very surplus. Like you start seeing yam everywhere. And at some point you see that there's not even yam, you never see yam at all. So it has its own season and it is annual. But for industrial growing crops, that one is not annually. It can be anytime. Yeah, it can be grown anytime. And an example of it is rubber. We also have potato as another good. So all these are goods. They are goods that you can be sold out, you can buy, you can exchange money, yes, to the buyer. They are all goods. So we have the exception. Okay, before exception, we also have the last type of good, that is things attached to or forming part of the contract. So this is also another part of this is also another part of good, another type of good rather. So these ones, they are like, they said things forming part or attached to the land. So what are the things that are attached to the land? We have trees, we have timber, we have a lot of things that are attached to the land, and they will be good so far that so far as they will be severed. Wait, let's get it better. They said things attached to or forming part of the land are also known as good. So what are the things that are attached to or forming part of the land? An example, I said we have trees. We have trees as part of things that is forming part of the land. We also have maybe timber forming part of the land. So before tree can be said to be good to be sell, it has to be severed, and severed in the sense that you have to be like you have to cut the tree down. It has to be like in term, like in an effective term, like in effective mode to be sold. Like it has to be in a better situation before it can be sold. You cannot say it is a good when the tree is still joined together with the land. So before it can be termed to be good, it has to be cut down, it has to be severed. If you look at the definition of good, you see that they said that provided that they are to be severed before they will be before they will be sold in that contract. So the trees have to be cut down, and every other things like timber, they have to be severed. They have to like pluck them out. You have to cut them. Same also as emblements and industrial growing crops. Before you can sell them as goods, you have to make sure that they are severed, they are not still joined to the land. When you when you grow maybe yam, it will still be attached to the land. So you have to sever it, you have to like cut them down before you can now sell them out as good. Now we have exception that are not good. We have things in action and money. These are not good. They are not classified as good in law. Things in action, they are intangible things. They are things you cannot touch. That like, they are things you cannot they are intangible. Yes, there are things you cannot like maybe touch. Maybe for example, we have shares. Maybe they want to give you shares in a company. They are not something you can like not something you can hold. They are intangible. You can only hear about it. You can only invest in it. Not that you would see it as good. Also, we have money. Money also is not classified as good in law. So that is the definition of goods in sales of goods as provided in section 62 sub 1 of Sales of Goods Act. Now let's move on to the classification of goods. Yes, the classification of goods. We have various classification of goods, and they include the specific goods, the ascertained goods, the unascertained good, the existing good, and future goods. I'll repeat them. We have the specific, ascertained, unascertained, existing, and future goods. Now for specific goods. Pursuant to section 62 sub 1 of Sales of Goods Act, specific goods are goods that will be identified and agreed upon. Like these are goods that will be identified, that will be known at the time the contract is made. I said there are goods that will be identified, like there are goods that you know that this is a specific good. How the way you will be able to know that this one is a specific good is the fact that there are goods that you will buy them at the point where the contract is made. For example, if Lola agrees to buy a fancy water bottle from the seller, and then the seller sold that water bottle to Lola at the point where Lola wants to buy the fancy water bottle, then that is a specific good. We know that okay, what Lola is buying is fancy water bottle. It is a specific good because it is taking place at the point where the contract is made, and this is basically an a common one. Yes, because every time you go out to buy something and then you get that thing, there are specific goods. There are specific goods. Maybe you go house there, you buy you buy your food, the seller sold it out to you. That is a specific good. Now we have ascertained goods. certain goods and specific goods are quite different. For a certain goods, these are goods that are to be identified, are to be known after the after the contract is made. They are to be known at a later date. While specific goods is known at the point where the contract is made. This one is to be known. A certain good is to be identified later, not when the contract is made. So an example of a certain good is maybe you ordered 50 bag of rice from a warehouse that is selling different kinds of rice, and you just ordered 50 bag of rice. At that particular time, you don't even know you don't know the exact rice they are going to give you. You would know it after they've supplied that rice to you. So that's why ascertain it is ascertain in the fact that you would be able to identify it after the contract is being made. After they supply that 50 bag of rice, that's when you'll be able to know that, oh, this is my good, and that is what the law called ascertain good. For unascertain good, these are good that are not known, they are not identified, and they are to be known by description. You only describe them. They are based on their kinds, their quality, their quantity. They are not identified at all. An example is you want to buy a if you want to buy a shoe. Yes, you told the seller you want to buy a shoe, a sneaker, size 42 sneaker. You see, the seller is selling a different kinds of shoe. The seller is selling different kinds of shoe, and you just told the seller that you want to buy size 42 shoe of size 42 shoes, and the people that produce it sabi make sneakers, something like that. Sha. At that particular point, you are not even seeing the shoe. You are just describing what you want to the seller. You don't know how the shoe is going to look like. It is after they've given you the it's after they've given you the shoe, that's when you know that, oh, this is the shoe I ordered. Oh, this is my size 42 sneakers. But time at the particular time you are entering into the contract, you don't know how it look like. You cannot even identify it. You only entered into the contract based on description. Now for existing goods. Existing goods are goods that are owned, possessed, acquired by the seller before the contract of sale. They are goods that are owned, they are acquired, they are processed by the seller even before the contract is made, meaning that they can be specific goods, they can be uncertain, they can be uncertain. So far as they are already in existence, the seller already possessed them before you entered into the contract. For example, if you go to a boutique that you want to buy something, you see the clothes there on the hanger, you see them everywhere. Like the seller already owned the clothes already before you want to come and enter the contract by buying the clothes from the boutique. So that is an existing good. They are already there. Also, we have future goods. These are goods that are not yet in existence, unlike existing goods that are already in existence with the seller. But for future goods, they are not in existence. They are not possessed at all by the seller, but they are to be manufactured or they are to be grown by the seller at a future date. This is an example of an agreement to sell. We differentiate a contract of sale and agreement to sell. For existing good, you can classify that as a contract to sell because everything you want to buy is already there. So negotiation can take place and then you also get what you want. But for future goods, that is an agreement to sell. The seller does not have the goods in hand. The seller would have to maybe go look for it, go buy, go manufacture, go grow in it before the buyer would have possession of it. And that's an agreement to sell. A typical example of an agreement to sell. And an illustration is maybe when you want to buy maybe you want to buy something that has not been invested. Maybe you want to buy an iPhone 18. So you have to wait until that iPhone 18 has been manufactured before you'll be able to buy it. So those are the classification of goods we have in sales of goods. And I hope you are able to grab everything easily. Now we'll be going on to the distinction between sales of goods and other types of contracts. Yes. So we have sales of goods differentiated from hire purchase. We have sales of goods different from exchange and sales of goods different from contracts of work and skills, yeah, and material, yeah, same thing. So for sales of good and hire purchase, we want to differentiate sales of goods from other contracts. So you will not be able to mix them. So you'll be able to identify whenever you see that, oh, this one is not sales of good, oh, this is hire purchase, oh, this is exchange. So you'll be able to identify them very well. Now for sales of good and hire purchase. For sales of good, from the definition in section 1 sub 1 of sales of good act, that says that contracts sales of good is a contract whereby the seller agree to transfer property in good to the buyer for monetary compensation. So from that definition we can see that sales of good involves the transfer of ownership. Is from the definition, it says the seller wants to transfer, or the seller is agreeing to transfer. And when you transfer something to the buyer, you mean that the seller will no longer be the owner of the thing. It will now be the buyer that owns the thing. So for sales of goods, there is transfer of ownership. You transfer goods to the buyer for the buyer to own it rather than the seller. You're transferring ownership. While for higher purchase, you are not you are not like transferring ownership. In higher purchase, okay, you want to me as an hire, I want to give you my car. You are going to ride that car for commercial use, and then you are going to deliver to me. You're going to pay me, not that I am giving you the possession of the car. But there is always an option to maybe after paying for that particular amount the IRN to give out the goods, then you can now own it. But normally for hire purchase agreement, there is no ownership. You don't possess as an hire. You don't give possession, like you don't give ownership. You just like it's totally different from sales of good. So in sales of good, it involves transfer of ownership, while hire purchase does you do not transfer ownership. The seller is still the rightful owner. The seller is still the rightful owner of that property. Yes, if I give out my car, if I give the person my car to be using it for commercial use, I'm still the owner of it, because you have to deliver to me and all the necessary things you have to do. Also, sales of goods include, you find two parties in sales of good, the buyer and the seller. While in hire purchase, you see three different person included. You see this, you see the ah, you see three different person. Me that want to give the goods, and the person that want to collect the goods, then a guarantor. So three parties are included in hire purchase, or like sales of good, where we have two parties, the seller and the buyer. Now, moving on to sales of good and exchange. Sales of good differentiated from exchange. Exchange in the sense that you are exchanging good for good, trade by barter. For sales of good, okay, let me start with exchange. For trade by barter, you are exchanging goods for goods for goods, and no other thing. You know, in the olden days, they'll say trade by barter, they're exchanging good for good. You give me rice, I'll give you groundnut oil. Nothing else is attached to it. But for contract of sale portion to section 1 sub 1 of sales of good act, it's defined what sales of goods is. And we say is that sales of goods include the monetary compensation, which is known as price. As you can see, that price is actually an important element of sales of good. Without price, I as a seller cannot even give you my goods, because you cannot just come and say you want to buy and you will not pay. You see that that price is a key important factor in sales of good. While trade by barter, exchange lacks it. It's just good for good. You give me good, I'll give you another good. There is no maybe monetary exchange in it. And that is a huge difference. So if you want to differentiate sales of good from exchange, you know that in sales of good, money is included. Portion to section 1 sub 1 of sales of good, that while exchange, there is no money. Money is not included. No monetary compensation is included. Now we have sales of good and work and skill. So now we want to differentiate between sales of good and contract for work and skill. They are quite similar, but it is also important for us to identify the difference between the two. For contract of sales, we said contract of sales involve the transfer of ownership. Here's the transfer of ownership of goods to the buyer. But a contract for work or skill, that is the fact that you are providing service, like you are is it like the contract is for a provision of skills. For instance, maybe I as a painter, you you enter into an agreement with me that I should help you paint the walls, and after I paint it, the court will not going to classify it as contract of sale. They'll classify it as the expertise of that person, that oh, the person uses his or her skill to paint the wall for you, and that is different from it's different from contract of sale. So contract of sale and contracts for work and skills is they are quite difficult to differentiate, but it is also important to know the difference. When you are providing, like, this is your skill, this is what you know how to do better, then that is provision of skill. But it is also different. For instance, maybe you are a person that you do artwork, like you provide out, you use your skill to create an artwork. If you've created the artwork, like, okay, this is my drawing, you already have the drawing down, you've already hanged it somewhere, you've hanged it somewhere that okay, another person can just enter and ask for the price, then the court is not going to classify it as your skill or expertise at that particular moment. They will see it as something that you are ready to transfer the ownership to other person. Like, you've drawn the thing, you finished the artwork, you've placed as a symbol that you want to sell it out, then the court is not going to classify it as your skill or your expertise. But if what you are doing, like what the contract entail, if the purpose of the contract is for you to draw, not that you've drawn it down already, like, but the purpose of the contract is maybe for you to paint, to draw, or do anything, then that one you are providing your service, you are using your skill, and it will not be done as contract of sale, but it will be contract of sale if it is you are transferring your ownership, as we've explained earlier. Now, those are the major difference of contracts with sales of good contracts. I hope the introduction of sales of goods is very clear to you. If there are any others that are not clear, my DM is open for more clarification. Thank you, and follow me for more legal concepts. Thank you.